So I'm recording this on Wednesday morning, August 31st. And the question I've been getting a lot over the last number of hours is my reaction to the brief filed by the DOJ late last night. You may remember that Donald Trump and his legal team, such as it is, filed a motion asking for a special master to be appointed in connection with the search of Mar-a-Lago and certain other relief. And the Department of Justice was required to respond by yesterday, and we wondered when that brief would come, and it came just a few minutes before midnight, just beating out the deadline. You may have heard also that the Department of Justice did something kind of unusual. Usually in cases like this, before that particular judge and that particular court, briefs can't be longer than 20 pages. In this case, DOJ asked if it could use 40 pages. They came in a few minutes before midnight at a clean 35 pages, so 5 pages to spare. And that's not the important part. The important part is what arguments they made and what facts they laid out. A lot of people predicted, I think correctly, that it may have been a legal mistake or a tactical mistake for the Trump folks to ask for relief, which was kind of late anyway, coming 2 weeks after the search itself, when the documents had already been seized, already been likely reviewed, and already been likely filtered. And the reason they said that was the motion by Trump and his lawyers would prompt a potentially detailed response that would be more damning for the former president. And I and others who said that were absolutely correct. One thing in the brief that's getting a lot of attention is an attachment. And the attachment shows a number of documents that remained at Mar-a-Lago that FBI agents found and seized that very plainly show red and yellow colored cover pages, the red one saying secret/SCI, and the yellow one saying top secret/SCI. So on their face, highly sensitive, classified markings located on the documents had not been turned over before, despite, as we've described, incredible accommodation, patience, and extensions given to the president and his team to turn over these presidential records. Among other things, by the way, DOJ argues Trump has no basis and no standing to contest anything with respect to the search and the handling of those documents because they don't belong to him. They're presidential records that don't get to remain with someone when they're the former president. But I found another attachment to be the most interesting thing in this motion. A few days ago, I was asked by Wolf Blitzer when I did an appearance on CNN when the affidavit was partially unsealed, mostly redacted, partially unsealed. And he said, is there anything that disappoints you with respect to these redactions? And I said, I'm not really disappointed because as a citizen, as a former prosecutor, I want to make sure that the integrity of the investigation is preserved, that a roadmap is not given to people who are under investigation, that witnesses are not at risk and won't be harmed. But I said the one thing that I would have liked to have seen, and I couldn't think of a reason why we wouldn't see it in the unredacted affidavit, was confirmation of the reporting by the New York Times, Maggie Haberman and others, which said that a lawyer for the former president of the United States had signed a sworn certification after accommodations were granted, after a subpoena was issued, signed a sworn certification that all the documents asked for had been returned and none remained. And we didn't see that in the unredacted affidavit. I'm not sure why, but we see it set forth in black and white in this legal memorandum, this legal brief by the Department of Justice. And I think this is incredibly important because it provides a basis and a justification for all of us, not just the court, but all of us to understand why they had to take the aggressive step of getting a search warrant. Because they tried again and again and again to get the documents, asking for them politely, collecting some documents, issuing a subpoena, visiting Mar-a-Lago. By the way, as the brief also points out, when certain agents went to Mar-a-Lago, they weren't allowed to search in all the places where some of these documents were. And DOJ's brief actually attaches the signed certification letter. It doesn't say who signed it, but it says it's a lawyer for the president. And it says, and I think this is important, so bear with me, based upon the information that has been provided to me, that's a lawyer saying based upon the information that has been provided to me, presumably by Trump himself and others. So he's hedging a little bit, right? He says, I am authorized to certify on behalf of the office of Donald J. Trump the following. And among the things he certifies to is that a diligent search was conducted of the boxes that were moved from the White House to Florida, which seems to encompass all of the boxes that were moved from the White House to Florida. B, this search was conducted after receipt of the subpoena in order to locate any and all documents that are responsive to the subpoena. And certainly anything classified or marked classified would have been responsive to the subpoena. And the certification goes on to say, and this is maybe the most critical, D, no copy, written notation, or reproduction of any kind was retained as to any responsive document. So that picture is worth 1,000 words, as they say, but that is so in juxtaposition with this signed certification letter in which a direct representative, legal representative of the former president says, we don't got any more. We gave it all to you. None has been retained. And then they go in with a search warrant and they find that that's false, that it was a lie. Who's at fault for that lie? Well, we'll have to see what the facts tell us, but it's not good for the former president. With respect to the issue of obstruction, if someone says they gave stuff to you and it turns out that was not true, the implication is that was intentional and designed to interfere with an appropriate legal process. So that, I think, is devastating, and I'm not quite sure why it wasn't in the unredacted affidavit, but we have it now. As for the special master, I disagree with some of my colleagues and friends who are very, very stridently opposed to the appointment of a special master. I think the government is correct. The former president doesn't really have standing. It's in any event moot because the documents have already been filtered. But even the government in this brief is not particularly aggressive about the special master. They say things like a special master would be unnecessary. A special master is, quote unquote, disfavored in this context. At the end of the day, maybe it causes some delay. Maybe it's a little bit silly because the work has already been done, but I don't think it's the most important thing in the world with respect to this matter. The most important thing is the evidence of obstruction and likely the knowledge and intent of the former president in keeping these documents after repeated legitimate requests to give them back.